As all of you know, there's an effort underway to undermine the National Labor Relations Board, including legislation which represents a subversion of the judicial process. Congressional demands that the NLRB turn over internal documents related to the prosecution of Boeing under threat of congressional subpoena represents an abuse of congressional power. The bill that will be presented to Congress would have the effect of discouraging union membership, which in the private sector has plummeted from 36% in the early 1950s to 7% today. If the NLRB, an independent agency tasked by Congress to protect employers and employees alike against violation of labor laws, if the NLRB were weakened such that it cannot impose a meaningful penalty on an employer who is found to have violated labor laws, it would send a signal to American workers considering unionization, and it wouldn't be a very positive signal. So this briefing today will give everyone here an opportunity to go deeply into this question about the relationship between the NLRB and the upholding of the rights of working men and women. I want to begin by thanking Sarah Fox and Pat Bertucci for coming here to be part of this important briefing. I appreciate your dedication to workers' rights and to strengthening our economy. Last night I spoke on the floor of the House of Representatives about the importance of shoring up our economy and the trends that have brought America to this very difficult state that we're in today. Unemployment is at 9.1% and the economy is stalled. Real wages are declining and have been for a long time. Wealth is being accelerated upwards at an alarming rate. Poverty is growing. Benefits like health care and pension are being squeezed from many different directions. And the defense, the real defense against all of these trends, is the workers' right to organize, the right to collective bargaining. What we have going on in America today is a direct attack on that right. And so this briefing is aimed at being able to defend workers' rights to organize by preparing us to be able to effectively challenge the legislation which will be brought before the Congress to challenge it with facts. So I want to thank Sarah Fox, the legal counsel from the AFL-CIO, for being here, and Pat Bertucci, who's a member of the IAM, the International Association of Machinists and Aerospace Workers, and employee of the Boeing Company. Thank you very much for being here. And whichever one of you would like to start first, feel free to. Yeah, thank you.
Thank you. Good morning. As the Congressman said, my name is Patrick Bertucci. I'm a third-generation Boeing employee. I put the wings on the 737 in Renton, Washington. I'm here to speak on H.R. 2587, which will stop me and many workers of their rights to collectively bargain. I'm not willing to sacrifice a tradition that goes back 3 generations so Boeing can have an added competitive advantage and not follow long-established labor law. I would just like to give my daughter the same opportunities that were given to me and have it be her choice and not Tim Scott's. I am the 3rd generation of Boeing employees. We stood together, joined a union, bargained for a better life, and established the middle class. I have said it before, I want the Boeing company to succeed. I truly believe in this company. I and thousands of other Boeing employees have done their part to make this company incredibly successful and will fight to keep it profitable and strong. When Boeing moved to Chicago, I guess that was a sign. It seems since they moved, there's been a huge disconnect between Boeing corporate and the workforce. Seeing how the outsourcing of the 787 went, I can't figure out why Boeing won't pull back work into the United States and back into the hands of the American workers. After negotiations broke down during our last contract and we exercised our right to strike, I was shocked to hear and see that Boeing would relocate its 787 line because we struck. When I learned that the NLRB had brought the case forward, I was proud. I was proud that someone was standing up to defend our rights, even against a big company like Boeing. We're going into bargaining next year, and the company is trying hard to intimidate the workforce using that second 787 line to scare the employees. I have first line managers on the shop floor telling employees, hurry up, get it done, or we're moving your work to South Carolina. In closing, I would just like to say, if the NLRB is not allowed to pursue this case with the way the law was written, we will all be in trouble. And every American's right to be in a union will be threatened. Thank you.
Thank you very much, Patrick Bertucci. Sarah Fox, legal counsel for the AFL-CIO.
Good morning. I'm here, as the Congressman said, on behalf of the AFL-CIO to talk to you a little bit about the law and exactly what it is this bill would do to change the law and the impact that that would have on worker rights. I should add that in addition to representing the AFL-CIO, I served as a member of the National Labor Relations Board for 5 years during the Clinton administration. So I am equally appalled to see the attacks on the agency itself and the men and women who are working hard there, many of whom are my former colleagues, to be fair to workers and to the purposes and policies behind this act. I think it's important to know that no matter what you or any of your principals here might think about Boeing, about the rightness or wrongness of their position in this case, it is still, I think, extremely important that this bill not pass. And there are really 3 reasons for that. The first is that this bill would directly interfere in a pending legal proceeding on behalf of a particular employer, which is pretty unprecedented. Boeing, I know, is claiming that it transferred this work for legitimate business reasons. It is claiming that workers will not lose jobs. There's plenty of work for them. And is certainly complaining that the remedy of having to move work back would be burdensome. Those are all arguments that Boeing will have a full opportunity to make in this proceeding. There will be a hearing before the ALJ. It's already started. There will be a hearing before that will then be appealable to the full board, and after that, they can appeal to the courts of appeals. It's also important to understand that even if it is shown that an intent to discriminate against workers for exercising their protected rights was a motivating factor in a decision, if the employer can show that they would have made the same decision anyway, then they won't be found guilty of an unfair labor practice. In addition, although the standard remedy for a situation where an employer has moved work for discriminatory reasons is for the board to order that the work be returned, the board will not do so if the employer can make a showing that it would be an undue burden. So the Boeing here, regardless of how you feel about their position in this, will have a full opportunity, and this is not necessarily the draconian remedy that they are presenting it as. It is also a remedy that has been used by the board and endorsed by the courts since the earliest days of the National Labor Relations Act. And the Act itself provides, as I think many of you recall from the debate over the Employee Free Choice Act, very weak penalties in general. Unlike other kinds of statutes that prohibit discrimination on the basis of race or sex or age, where an employee who is discriminated against can get compensatory damages, sometimes even punitive damages, consequential damages. Under the National Labor Relations Act, an employee who has lost their job because of discrimination against them because of their union activity is only entitled to back pay, reinstatement, and if their job is still there, and back pay simply to cover the time between when they were laid off and when they can be reinstated.